You're tuned in to Agriculture Today, and we start our Wednesday show hearing from K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you, Shelby.
And Roger, discussing a recent blog article from yourself, and within this article, you describe this topic as the silent engine of the modern farm. So what are we talking about today?
Well, we're talking about intellectual property. And indeed, I think the entire ag landscape has been undergoing a digital and biological revolution. We could wrap into this drought-resistant hybrids, proprietary algorithms for precision planting, or big data that's harvested by a fleet of autonomous combines. But this intellectual property issue is, as you say, the silent engine of the modern farm.
And so while we're thinking about this and maybe thinking about research and development tax deductions, what has changed or per se returned to the market?
Well, I think from a legal and tax perspective, intellectual property or IP is often misunderstood. And for many producers, it really leads to missed tax deductions or even worse, unintended tax hits when it's time to sell. And so there are things that farmers and ranchers need to know. And I'm going to start with, I think where we should start is with the One Big Beautiful Bill Act, and particularly with respect to the change in the rules with respect to the deductibility of research and development costs. And what we have now is full expensing is back. And that's a change in the rule. We used to have that, and then TCJA changed that and said, now you got to spread your R&D costs over 5 years, but now OBA brings it back. So for years starting after 2024, you get to fully deduct domestic R&D costs in the year you spend the money. Now, there's a special catch-up relief rule that's in there, and that gets pretty technical. So if you had unamortized costs from the years that were in limbo, basically because of OBA, that would be 22, 23, and 24, there is a way to claim those deductions now. But this applies to domestic R&D. So if you're sourcing your tech from overseas, you're still stuck with a 15-year wait to fully deduct those costs. But documentation is going to be the key. And we just had a recent tax court case on this, Shelby. And what that case tells us is that if you're going to qualify for the R&D tax credit, your research and experimentation expenditures have to be rooted in hard sciences. That means biology, chemistry, or engineering, and they must involve a process of experimentation that's intended to eliminate uncertainty. So if you're testing a custom software interface for your equipment or a new biological soil amendment, you want to keep records of your failures because the court wants to see the scientific process, not just the final result. And that's just one area of what could be missed tax deductions based on something associated with intellectual property.
And what are some other examples you see of intellectual property that would qualify for this tax deduction?
With the advent of bioengineered seeds, we've got intellectual property rights associated with seed, and farmers will often ask me about the right to save seed. And whether they have that right or not actually depends on the legal shield that protects the plant. And so if that plant is protected by the Plant Variety Protection Act, you can save some seed. It's a limited right. But commonly we'll see that with respect to traditional varieties, and you can save seed to plant on your own acreage. If the seeds are protected by a general utility patent, then you cannot save the seed. And so most of our modern traited seeds that have traits that are resistant to various types of herbicide, those would be covered by utility patents. You cannot save those seeds. And in fact, when you buy that seed, you have to sign a technology agreement saying that you will not save it, and you get prosecuted, and the companies do protect their intellectual property rights pretty closely in that type of seed.
For someone who's maybe looking at the seed of the Plant Variety Protection Act, and you mentioned it being planted on your own acreage, is that them needing to own that acreage if they're wanting to do this, or could they be leasing it?
Well, you could plant it on acreage that you own and acreage that you farm. So a tenant can save the seed to plant on their acreage that they're farming or on their own acreage. But it goes either way, but you just can't go beyond that. And so that's acreage that you basically think of it as acreage that you operate. And you don't want to expand that out unless you have increased your ownership or usage of that property, because the companies will monitor the farm's that you are operating at the FSA office, and they'll see if your acreage hasn't gone up, but you're not buying, or let's say your acreage has gone up, but you're not buying more seed. That's an indication that you might be skirting some of the protections on those seeds. So be very careful with that. There are some punitive damage awards that can be awarded in these types of situations. You just want to stay away from those things.
And while we're talking about taxes and intellectual property, is there a long-term capital gain treatment that some people might also qualify for?
Yeah, if you invent a new tool or a plant variety and you sell the patent, you might qualify for long-term capital gain treatment. That means a lower tax rate, but it's a pretty narrow gate. This only applies to individuals. So if you do it through your corporation, a C corporation or an S corp, you're not going to be able to access that fast track to capital gains. Plus, there's a related party trap. If you sell your patent to a family-owned entity where you own 25% or more of that entity, you lose the tax advantage. And so the IRS is basically saying, well, you're selling to yourself. You shouldn't get a tax break on that.
How would someone show that maybe it is an individual just doing this work of maybe inventing a new plant variety?
Well, as long as you don't have some type of entity that's been created and on file with the state, which makes it very easy to check, because if you file a corporation, a partnership, an LLC, you have to file some type of certificate of existence. Then you're operating as an individual, plus they're going to look at your tax returns. And so if you're reporting that on individual schedule, rather than some type of corporate return, that's going to bolster your position that you did not create an entity and you are qualified for the long-term capital gain treatment as an individual.
And something maybe not super tangible, but important for farmers to also keep in mind, what you termed the invisible asset, and what is this?
Yeah, this can come into play when you sell a farm and or when you buy a farm. Who owns the yield maps? Who owns the soil health records? Is it the landowner? Is it the tenant? Is it the equipment manufacturer? Well, we know that ag data is increasingly being treated under the law like a trade secret. So if you buy a farm, the data that comes with it is an intangible asset that you could usually write off or amortize that cost of that data over 15 years. Now, if you create the data, you can't write off the value of that. So you can't write off the value of your own data, but it still has immense value to you during a sale. So what I'm saying here is don't rely on handshake deals for digital assets. Ensure your lease or purchase agreements include a data use agreement to clarify who owns that digital footprint associated with that land.
While we're thinking about the year of 2026, what are things that you recommend people keep in mind?
I'd say do an audit of your R&D. You may not have ever thought about this or done this before, but separate out your routine production costs from your experimentation costs to maximize your deductions under the new tax law. Maybe that's an issue for you, maybe it's not, but maybe it's something you need to think about. And then if you're developing intellectual property, talk to a professional in that area before you incorporate, because once you move your intellectual property into a corporation, that can sometimes lock your tax benefits away from you. And then formalize your data ownership, whether you're a landlord, whether you're a tenant. Who owns the yield? Define who owns the yield in the soil data in writing. Put that in writing. So my whole point on all of this, Shelby, is that intellectual property is not just for Silicon Valley anymore. It's a farm gate issue. And so if you stay ahead of these legal shifts, you're going to protect the future of your operation.
And Roger, you mentioned that if someone's maybe wanting to develop some intellectual property, talking to a professional in that area, and is that professional going to be an intellectual property lawyer, or what terms might be used to describe professionals in that industry?
No, that's a good question. It could indeed include somebody that is trained in intellectual property law, but also here you have a lot of tax concepts. So your tax professional should be able to advise you with respect to the transfer, the purchase, the sale of and development of intellectual property, particularly when we're talking about R&D costs and intellectual property associated with a farm sale or farm acquisition. So your tax professional, intellectual property attorney, and sometimes it'll depend on the exact type of intellectual property that's involved. But this is something that decades earlier we have not talked about. But this is the technological advance, and it does impact tax and law.
So as we look forward for intellectual property, what do you think you might see?
Well, what we see, I think, is across the board with respect to crops, with respect to livestock, with respect to soil. There's all types of intellectual property that's developed in all areas of farming and ranching. It's not just one aspect. And so when a farm is bought or sold, when research and experimentation costs are incurred to develop some new technology, that all has important tax and legal implications to it. Farming's not as easy as it used to be.
Roger, I appreciate you taking the time to join us today.
Thanks for having me.
That was K-State and Washburn law professor Roger McEowen. If you'd like to read more on this topic, I will link his blog article titled Navigating Intellectual Property on the Modern Farm in today's show notes on agtoday.net. You can also find it by going to agmanager.info.